long as the perception remains that he is this influential ringleader and his mere presence on campus is itself detrimental to the interests of justice, then I fear that we will, in fact, be back on the same issue. Because these facts, I mean, the only fact, Justice Cameron, and perhaps Justice Froneman as well, the only fact is the passage of time, whether or not that has cooled down the situation or what. But the material facts are exactly the same facts that were before the magistrate.
Would it make any difference if this court were to indicate in the judgment that there may well be, without making any finding, because that would not be within its province, that there may well be additional factors or considerations that the magistrates at a renewed hearing might be able to take into account?
Yes, Justice Cameron, the way I propose to answer Justice Froneman's invitation about remedy is that perhaps the correct way is that these considerations go into the question of remedy. In other words, whether the court itself decides to grant the bail or remits the matter for a reconsideration before the magistrate, but with clear directions. But that's then a remedy question after having answered our first proposition that there has been a misapplication of the law.
Understand what you regard as first prize.
Mr. Ngogai, would the bail application have to come before the same magistrate or not necessarily?
We were told, I mean, I must ask this from the people who practice in those courts, but when I brought the second bail application on the strategic basis that Justice Cameron is suggesting, we were told that it had to go to the same magistrate. And that is why we brought it before the same magistrate. Justice Kabinde.
If you can just clarify one aspect for me. When you look at Dlamini, it deals with broad policy consideration contemplated in the interest of justice.
Yes.
In the bail application. Now, if you look at what the magistrate does in the judgment, I think it's page 286. The magistrate, in the middle of that page, says the following. The applicant has the power to influence others as seen in the video and will endanger the safety of the public or any particular person.
Justice Kabinde, where are you reading? Because at 286, I don't have...
I'm looking at the judgment of Magistrate Yonk.
Oh, yes, sorry, Justice Kabinde, I found it.
It's annexure FA7.
Yes, I found it, Justice.
Look at the middle of that page.
Yes, the court does not share the sentiments.
Yes, the court does not share the sentiments of the defense that the applicant is just a victim who only wants to go to varsity and write his exam so that he can carry on with the rest of his life. Now the point is this one. It has always been accepted that the likelihood of risk that an accused, if released on bail, might endanger the maintenance of law and order, or public safety, or even national security, is a valid ground for refusing of bail.
Yes.
Now let's look at what the court does. This court does in Dlamini on paragraph 53 in relation to the policy considerations contemplated in the interest of justice. The court tells us what should actually happen.
Yes.
It guides that all other weighty factors should be considered in the determination of the interest of justice.
Yes.
Now, my question is, we see that the magistrate has relied solely on one ground, that the detainee is likely or probably to endanger the society.
Yes.
I suppose that he bases this on the video utterances.
Yes.
Did the magistrate not misdirect himself or in not looking at all other factors?
Yes, we suggest, Justice Kabinde, that she did. She misdirected herself in misinterpreting the law. She also misdirected herself in misapplying the law, because what she missed in the application of the law is the broad interest of justice. And that becomes particularly prominent in the second application on new facts. Because on those new facts, if one compares paragraph 52 of Dlamini, where this court stated, the interests of justice in regard to the grant or refusal of bail, therefore, do focus primarily on securing the attendance of an accused at the trial and on preventing the accused from interfering with the proper investigation and prosecution of the case. What we then find in the second bail application is we find that it is common cause that the accused will in fact attend his trial. We also find that it is common cause that the investigation has been completed. But what the magistrate finds in page 92, at the end of the page, counsel submitted that the fact that the investigation is complete is a new fact that warrants the release of an accused on bail, and he cannot destroy evidence or interfere with witnesses. Then she says it is correct that the investigation is complete, but this doesn't mean that the applicant can simply be released on bail. The probability still remains that the witnesses could be interfered with, especially after the statements are handed over to the defense. There are no facts, no circumstances, not even the identification of these witnesses that might presumably be interfered with after the statements are handed over to the defense.
Where the witness is not known,
They are known now, Chief Justice.
the police and what, members of management?
Yes, it's 14, there are 17 witnesses because they gave this to us on the 6th of December. It is 14 police officers and 3 members of management at the university.
So he will intimidate management and the police.
Yes. Quite, Chief Justice. In the course of my address, I have straddled all of the various topics, and I submit that the court at least would appreciate the points I was trying to make, and I think it is time to hand over to my leader.
Yes, Mr. Mpofu.
As the court pleases, Chief Justice, Deputy Chief Justice, and Justices, mine is hopefully not going to be a long address. It is directed at maybe supplementing the broader interest of justice test, not the one in section 60 that Malena Jr. has very eloquently addressed.
Maybe before you go there, why do we have jurisdiction?
Yes. Well, you have jurisdiction because the matter implicates, and I will piggyback on some of the discussions that have been articulated. The matter implicates not only the interpretation or section 39(2) and the various other sections of the Constitution, but it is a matter that directly affects what happens in the courts on a daily basis in terms of bail applications. And if the interpretation of the relevant sections and also of the judgment in Dlamini, which is the leading judgment, is a matter that might be affecting thousands and thousands of magistrates' decisions that are happening as we speak, then the first issue being that it implicates constitutional issues is clear-cut. Then the question of the interest of justice with respect flows naturally from just the number and the importance of the constitutional sections that are implicated.
Well, for section 35(1)(f) contemplates that the Constitution does allow, or rather permit, the deprivation of the freedom, in the sense that a detainee can be kept in detention until he is tried.
Absolutely. We don't quibble with that, Deputy Chief Justice.
Yes, I'm still asking.
Yes, but bail by definition, or rather arrest by definition, is a deprivation of some liberty.
Yes.
So some of it is allowable, and it has to be understood,
Yes,
provided,
but
of course, that
let me
it is.
continue with my question.
Oh, yes.
You interrupted me.
Sorry.
If a particular detainee is kept for a number of months in detention before he or is tried, what is the impact of that? Does that not impact on this person's liberty?
Absolutely.
Because this person is presumed to be innocent.
That is exactly, the Section 35 point rests absolutely on the presumption of innocence. And you're 100% correct, Deputy Chief Justice. With every day that passes, that's why this weighing process that Malene Jr. was talking about becomes important and, as it were, continuous. Because that weighing process, as it was in November, is now aggravated by the additional 3 months that we're talking about. As we speak, the accused person is entering the 6th month in detention this week. And therefore, I would agree with the Deputy Chief Justice.
Just to clarify one aspect. I read in the heads of argument by the applicant, if I'm correct, that it is common cause that investigation had been completed.
Absolutely. It is common cause that investigations are completed, and it is common cause that is not a flight risk. Those are the basis to come back to what happened at the SCA, upon which the SCA was nudging the parties to settle this matter. Because it said, on the basis of these 2 facts, which means the only remaining fact that brings us here is this notion that he might once again break his bail conditions, or he might once again attend an unlawful gathering. If that is the only thing, really, that is making the person to be kept for 6 months, as we speak now, some possibility that he might actually attend an unlawful gathering, which is what he's accused of having done in the context of breaking his bail conditions.
Last question. Do we know when these investigations were completed?
On the 6th of December. By the 6th of December, they had been completed. Thank you.
When did it become common cause that he is not a flight risk?
That is now common cause.
No. Since when?
Well, the latest would have been since it was so identified by the SCA.
Well, I'll tell you why I'm asking. One or both of my colleagues asked the question, isn't it preferable or more appropriate then that you approach the magistrate's court on the basis that circumstances have changed? And I'm affording you the opportunity to deal with that aspect.
No, Chief
The
Justice.
investigation has since been completed. It's common cause that is not a flight risk. I forgot the other factor that you articulated. Don't those new factors explain why it might be more appropriate to approach the magistrate's court again?
Chief Justice, with respect, that would be the case had the findings that were appealing against been based, for example, or among others, on the fact that he was a flight risk. He was not. So that factor, Chief Justice, was not one of the factors that we're bringing here, because even at that stage, it was not, and I don't understand that to be what my learned colleagues will even be relying on at any stage of this matter. So it's not a new fact, or rather, if it is a new fact, it's not one that is relevant to the issues here.
Completion of the investigation?
The relevance of the completion of the investigation is twofold, Chief Justice.
No, in the sense of it being a new factor, hopefully to be taken into account by the magistrate should bail application be launched, unless you're saying to me it was already
Absolutely.
known when the second application was launched.
Yes. Both when the second application was advanced, Chief Justice, as well as when the High Court matter took place, that fact was known and I should assume accepted.
The identity of witnesses, that they don't seem to be of the kind that could be intimidated by a student. Is it not a new factor that could...
That was argued extensively in the High Court, Chief Justice. So all those facts, as it were, are new, or they might even have been worsened by the passage of time, but they have been canvassed in the court's core at some stage or another. As court, please.
Mr. Mpofu, if we decide the appeal, we have to decide it on the facts before the magistrate at that time. So even if we're with you on your arguments that there was a misdirection, then this court must make its own assessment of whether the balancing exercise in terms of Dlamini, of the facts obtaining at the time the magistrate made his judgment. So we won't be entitled to take into account when we do that, if we're on your side, that a further 2 months have elapsed, that it's quiet on campuses and the like. Am I correct?
Yes and no, Justice Froneman. For the purposes of the broader discussion on interests of justice, you would be entitled to take that fact into account. But yes, as far as this is an appeal, obviously the time would be frozen. All I would add is to invite the court to freeze the time, not at the time of the first bail application, but at the time of the second one, where, as I was interacting with the Chief Justice, the new, so-called new facts were already known.
Mr. Mpofu, it is a fact to take into account that during the second bail application, things had become different on campus. Violence had abated, investigations had become completed, almost completed, and as a new environment, insofar as violence is concerned, had taken place.
That is correct, Justice Khampepe. And if I'm not mistaken, the university was either closed or the examinations were almost towards the end.
The only problem is that still, notwithstanding those factors, the magistrate found the applicant to be a ringleader with influence.
Yes, and in fact, there are two things, Justice Khampepe. One is that she unjustifiably, because there was no such evidence, made this ringleader finding. But also, she positively made the finding that there are no new circumstances, which is startling in the face of what we all know to have been the case, at least as at 29th of November. So on those two grounds alone, the ringleader issue just comes out of the blue. No evidence was led about it. And secondly, the new facts clearly existed on everybody's version.
I don't know what to make of the fact that he's a ringleader if it is established, but was he not proven to be a leader, an influential person?
Influential person?
Who, when he speaks, the crowd listens.
Well, if that was a crime, Chief Justice...
No. Just as a factor to take into account,
yes,
whether or not he does have the capacity to sway the opinions of the people, to direct, and to be followed when he says, yes, this is where to go.
Yeah, with respect, the Chief Justice is correct. However, this was not, there's a clear distinction. The word ringleader in this context is loaded, is deliberately loaded to suggest something more than leadership, admirable leadership qualities.
You say it has sinister connotations.
Absolutely. And it was intended for that effect, and only in that, the magistrate could never have said, I'm refusing to release him from prison because he shows great leadership qualities. So the use of the choice of the word ringleader was meant to have the loaded impact of troublemaker type of thing, which is different from someone who might have impactful leadership skills. Now,
I'm sorry. Has a trial date been set in this matter?
No, it hasn't. In fact, the relevance, Justice Jafta, of the fact is that as we say in the affidavit, the trial date was postponed, or rather the trial was postponed at the instance of the state, which indicated either a state of unreadiness or...
To be in the district or regional court?
District or regional court?
It's been transferred to the regional.
It's been transferred to the regional court, I'm informed. Now,
There's a dispute, Mr. Mpofu, on the cause of the delay. I think the state is suggesting that the delay is as a result of the defense. They say they arranged for a pre-trial conference late last year, which could not go on because of the defense. And if I'm not mistaken, I think early this year again, and then they say that the defense said they still want to consult with Mr. Khanyile. So there's a dispute there. I'm just raising that because
yes.
You stated as a matter of fact that the defense has delayed. Don't you want to engage that to the extent that it may be necessary at all to do so? I'm not
yes.
saying it is.
Fair enough, Justice Madlanga. My answer would be a short one, which says, let's accept that there is that dispute. What is not disputed is the fact that whichever party is at fault, the accused person has been in custody for almost 6 months now. And what also cannot be disputed, assuming that delay was on our side, is that the impact of him being in custody plays a huge role.
Mr. Mpofu, my criminal procedure is quite rusty. I would like to get an idea, why would it sound as though it's almost obligatory that this pre-trial conference should be held prior to the trial just going ahead?
Yeah, well, my experience, Justice Madlanga, is that those pre-trial conferences, quite frankly, don't serve much purpose in this, in the context of criminal trials. I've just attended one 2 weeks ago in Rustenburg. But it is some new development. It's a new thing that is done.
You have an unfortunate experience. It's a system I introduced which is working very well.
Well, in that case, it's a great system. Thank you, Chief Justice. I'm informed, for what it's worth, that on the 10th of February, new charges were added. Yeah. Now,
well, Mr. Mpofu, I'm sorry, and it may or may not, this may or may not depend on what
We seem to have lost the audio there. Those were live visuals coming to you from the Constitutional Court where the case of Bonginkosi Khanyile, a DUT student who was one of the leaders of the Fees Must Fall movement last year, has still been held in detention. It's a 6-month now in jail, and we're hearing some submissions there from his counsel trying to get a bail application approved there. We do know that bail was denied by the High Court as well as the Magistrates Court, and a date for his trial has not yet been set, although we do know that it will be set at the regional level, at the regional court level.